Rule 611B, Rule 611 Mode and Order of Examining Witnesses and Presenting Evidence. Scope of cross-examination. Cross-examination should not go beyond the subject matter of the direct examination and matters affecting the witness's credibility. The court may allow inquiry into additional matters as if on direct examination. C. Leading questions. Leading questions should not be used on direct examination except as necessary to develop the witness's testimony. Ordinarily, the court should allow leading questions, 1. on cross-examination, and 2. when a party calls a hostile witness an adverse party or a witness identified with an adverse party. On cross-examination, when a party calls a hostile witness an adverse party or a witness identified with an adverse party. Rule 612. Writing used to refresh a witness's memory. A. Scope. This rule gives an adverse party certain options when a witness uses a writing to refresh memory. 1. While testifying, or 2. Before testifying, if the court decides that justice requires the party to have those options. B. Adverse parties options. Deleting unrelated matter unless 18 U.S.C. 3500 provides otherwise in a criminal case. An adverse party is entitled to have the writing produced at the hearing, to inspect it, to cross-examine the witness about it, and to introduce in evidence any portion that relates to the witness's testimony. If the producing party claims that the writing includes unrelated matter, the court must examine the writing in camera, delete any unrelated portion in order that the rest be delivered to the adverse party. Any portion deleted over objection must be preserved for the record. C. Failure to produce or deliver the writing. If a writing is not produced or is not delivered as ordered, the court may issue any appropriate order. But if the prosecution does not comply in a criminal case, the court must strike the witness's testimony, or if justice so requires, declare a mistrial. 613. Witness's prior statement. Showing or disclosing the statement during examination. When examining a witness about the witness's prior statement, a party need not show it or disclose its contents to the witness, but the party must, on request, show it or disclose its contents to an adverse party's attorney. B. Extrinsic evidence. Extrinsic evidence of a prior inconsistent statement. Extrinsic evidence of a witness's prior inconsistent statement is admissible only if the witness is given an opportunity to explain or deny the statement and an adverse party is given an opportunity to examine the witness about it, or if the justice so requires. This subdivision B does not apply to an opposing party's statement under Rule 801D2. Rule 614. Courts calling or examining a witness. A. Calling. The court may call a witness on its own or at a party's request. Each party is entitled to cross-examine the witness. B. Examining. The court may examine a witness regardless of who calls the witness. C. Objections. A party may object to the court's calling or examining a witness either at that time or at the next opportunity when the jury is not present. Rule 615, excluding witnesses from the courtroom, preventing an excluded witness's access to trial testimony. A. Excluding witnesses. At a party's request, the court must order witnesses excluded from the courtroom so that they cannot hear other witnesses' testimony, or the court may do so on its own. But this rule does not authorize excluding 1. a party who is a natural person, 2. one officer or employee of a party that is not a natural person, if that officer or employee has been designated as the party's representative by its attorney. 3. Any person whose presence a party shows to be essential to presenting the party's claim or defense. Or 4. a person authorized by statute to be present. B. Additional orders to prevent disclosing and accessing testimony. An order under A operates only to exclude witnesses from the courtroom, but the court may also, by order, 1. Prohibit disclosure of trial testimony to witnesses who are excluded from the courtroom, and 2. Prohibit excluded witnesses from accessing trial testimony. Article 7, Opinions and Expert Testimony, Rule 701. Opinion testimony by lay witnesses. If a witness is not testifying as an expert, testimony in the form of an opinion is limited to one that is A. Rationally based on the witness's perception. B. Helpful to clearly understanding the witness's testimony or to determining a fact in issue. And C. Not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. Rule 702, Testimony by Expert Witness. Testimony by expert witness is a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not that A. The expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. B. The testimony is based on sufficient facts or data. C. The testimony is the product of reliable principles and methods. And D. The expert's opinion reflects a reliable application of the principles and methods to the facts of the case. Rule 703. Basis of an expert's opinion testimony. An expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. If experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject, they need not be admissible for the opinion to be admitted. But if the facts or data would otherwise be inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. Rule 704. Opinion on an ultimate issue. A. In general, not automatically objectionable. An opinion is not objectionable just because it embraces an ultimate issue. B. Exception. In a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Those matters are for the trier of fact alone. Rule 705. Disclosing the facts or data underlying an expert's opinion. Unless the court orders otherwise, an expert may state an opinion and give the reasons for it. Unless the court orders otherwise, an expert may state an opinion and give the reasons for it without first testifying to the underlying facts or data. But the expert may be required to disclose those facts or data on cross-examination. Rule 706. Court-appointed expert witnesses. A. Appointment process. On a party's motion or on its own, the court may order the parties to show cause why expert witnesses should not be appointed and may ask the parties to submit nominations. The court may appoint any expert that the parties agree on and any of its own choosing. But the court may only appoint someone who consents to act. B. Expert's role. The court must inform the expert of the expert's duties. The court may do so in writing and have a copy filed with the clerk, and may do so orally at a conference in which the parties have an opportunity to participate. The expert, number 1, must advise the parties of any findings the expert makes. 2, may be deposed by any party. 3, may be called to testify by the court or any party, and may be cross-examined by any party, including the party that called the expert. C. Compensation. The expert is entitled to a reasonable compensation as set by the court. The compensation is payable as follows. 1. In a criminal case or in a civil case involving just compensation under the Fifth Amendment from any funds that are provided by law. And 2. In any other civil case by the parties in the proportion and at the time that the court directs, and the compensation is then charged like other cost. D. Disclosing the appointment to the jury. The court may authorize disclosure to the jury that the court appointed the expert. E. Parties' choice of their own experts. This rule does not limit a party in calling its own experts. Article 8. Hearsay. Rule 801. Definitions that apply to this article. Exclusions from hearsay. The following definitions apply under the article. A. Statement. Statement means a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. B. Declarant means the person who made the statement. C. Hearsay means a statement that 1. The declarant does not make while testifying at the current trial or hearing, and 2. A party offers in evidence to prove the truth of the matter asserted in the statement. D. Statements that are not hearsay. A statement that meets the following conditions is not hearsay. 1. A declarant witness's prior statement. The declarant testifies and is subject to cross-examination about a prior statement, and the statement A is inconsistent with the declarant's testimony and was given under penalty of perjury at a trial, hearing, or other proceeding or in a deposition. B is consistent with the declarant's testimony and is offered. I. To rebut an express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive in so testifying, or 2. To rehabilitate the declarant's credibility as a witness when attacked on another ground, or C. Identifies a person as someone the declarant perceived earlier. 2. An opposing party's statement. The statement is offered against an opposing party, and A was made by the party in an individual or representative capacity. B is one the party manifested that it adopted or believed to be true. C was made by a person whom the party authorized to make a statement on the subject. D was made by the party's agent or employee on a matter within the scope of that relationship and while it existed. E was made by the party's co-conspirator during and in furtherance of the conspiracy. The statement must be considered but does not by itself establish. The statement must be considered but does not by itself establish the declarant's authority under C, the existence or scope of the relationship under D, or the existence of the conspiracy or participation in it under E. Rule 802. The rule against hearsay. Hearsay is not admissible unless any of the following provides otherwise. A federal statute, these rules, or other rules prescribed by the court. Rule 803. Exceptions to the rule against hearsay, regardless of whether the declarant is available as a witness. The following are not excluded by the rule against hearsay, regardless of whether the declarant is available as a witness. 1. Present sense impression. A statement describing or explaining an event or condition made while or immediately after the declarant perceived it. 2. Excited utterance. A statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. 3. Then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, such as motive, intent, or plan, or emotional, sensory, or physical condition, such as mental, feeling, pain, or bodily health, but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to the validity or terms of the declarant's will. 4. Statement made for medical diagnosis or treatment. A statement that A is made for and is reasonably pertinent to medical diagnosis or treatment, and B describes medical history, past or present symptoms or sensations, their inception, or their general cause. 5. Recorded recollection. A record that A is on a matter the witness once knew about but now cannot recall well enough to testify fully and accurately. B was made or adopted by the witness when the matter was fresh in the witness's memory, and C accurately reflects the witness's knowledge. If admitted, the record may be read into evidence but may be received as an exhibit only if offered by an adverse party. 6. records of a regularly conducted activity. A record of an act, event, condition, opinion, or diagnosis if A, the record was made at or near the time by or from information transmitted by someone with knowledge. B, the record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. C, making the record was a regular practice of that activity. D, all these conditions are shown by the testimony of the custodian or another qualified witness or by certification that complies with Rule 902.11 or 12, or with the statute permitting certification. And E, the opponent does not show that the source of information or the method or circumstances of preparation indicate a lack of trustworthiness. 7, absence of a record of a regularly conducted activity, evidence that a matter is not included in a record described in paragraph 6 if A, the evidence is admitted to prove that the matter did not occur or exist. A record was regularly kept for a matter of that kind. And C, the opponent does not show that the possible source of the information or other circumstances indicated a lack of trustworthiness. 8, public records. A record or statement of a public office if A, it sets out I, the office's activities. I, a matter observed while under a legal duty to report, but not including in a criminal case, a matter observed by law enforcement personnel. I, in a civil case or against the government in a criminal case. Factual findings from a legally authorized investigation. And B, the opponent does not show that the source of information or other circumstances indicate a lack of trustworthiness. 9, public records of vital statistics. A record of a birth, death, or marriage if reported to a public office in accordance with the legal duty. Period. 10, absence of a public record, testimony or a certification under Rule 902 that a diligent search failed to disclose a public record or statement if A, the testimony or certification is admitted to prove that I, the record or statement does not exist, or I, a matter did not exist, a matter did not occur or exist at a public office regularly kept a record or statement for a matter of that kind. And B, in a criminal case, a prosecutor who intends to offer a certification provides written notice of that intent at least 14 days before trial, and the defendant does not object in writing within 7 days of receiving the notice unless the court sets a different time for the notice or the objection. 11, records of religious organizations concerning personal or family history, a statement of birth, legitimacy, ancestry, marriage, divorce, death, relationship by blood or marriage, or similar facts of personal or family history contained in a regularly kept record of a religious organization. 12, certificates of marriage, baptism, and similar ceremonies. A statement of fact contained in a certificate, A, made by a person who is authorized by a religious organization or by law to perform the act certified. B, attesting that the person performed a marriage or similar ceremony or administered a sacrament. And C, purporting to have been issued at the time of the act or within a reasonable time after it. 13, family records. 13, family records. A statement of fact about personal or family history contained in a family record, such as a Bible, genealogy, chart, engraving on a ring, inscription on a portrait, or engraving on an urn or burial marker. 14, records of documents that affect an interest in property. The record of a document that purports to establish or affect an interest in property if A, the record is admitted to prove the content of the original recorded document along with its signing and its delivery by each person who purports to have signed it. B, the record is kept in a public office. And C, a statute authorizes recording documents of that kind in that office. 15, statements in a document that affect an interest in property. A statement contained in a document that purports to establish or affect an interest in property if the matter stated was relevant to the document's purpose, unless later dealings with the property are inconsistent with the truth of the statement or the purport of the document. 16, statements in ancient documents. A statement in a document that was prepared before January 1st, 1998 and whose authenticity is established. 17, market reports and similar commercial publications. Market quotations, lists, directories, or other compilations that are generally relied on by the public or by persons in particular occupations. 18. Statements in learned treatises, periodicals, or pamphlets. A statement contained in a treatise, periodical, or pamphlet if a. the statement is called to the attention of an expert witness on cross-examination or relied on by the expert on direct examination, and b. the publication is established as a reliable authority by the expert's admission or testimony, by another expert's testimony, or by judicial notice. If admitted, the statement may be read into evidence but not received as an exhibit. 19. Reputation concerning personal or family history. A reputation among a person's family by blood, adoption, or marriage, or among a person's associates or in the community concerning the person's birth, adoption, legitimacy, ancestry, marriage, divorce, death, relationship by blood, adoption or marriage, or similar facts of personal or family history. 20. Reputation concerning boundaries or general history. A reputation in a community arising before the controversy concerning boundaries of land in the community or customs that affect the land, or concerning general historical events important to that community, a state, or nation. 21. Reputation concerning character. A reputation among a person's associates or in the community concerning the person's character. 22. Judgment of a previous conviction. Evidence of a final judgment of conviction if a. the judgment was entered after a trial or guilty plea, but not a nolo contendere plea. The conviction was for a crime punishable by death or by imprisonment for more than a year. C. The evidence is admitted to prove any fact essential to the judgment. And D. When offered by the prosecution in a criminal case for a purpose other than impeachment, the judgment was against the defendant. The pendency of an appeal may be shown, but does not affect admissibility. 23. Judgments involving personal, family, or general history or a boundary. A judgment that is admitted to prove a matter of personal, family, or general history or boundaries if the matter A was essential to the judgment, and B could be proved by evidence of reputation. 24. Other exceptions transferred to Rule 807. Rule 804. Rule 804, hearsay exceptions. Hearsay exceptions. Declarant unavailable. When the declarant is unavailable as a witness. A. Criteria for being unavailable. A declarant is considered to be unavailable as a witness if the declarant, 1, is exempted from testifying about the subject matter of the declarant's statement because the court rules that a privilege applies. 2. Refuses to testify about the subject matter despite a court order to do so. 3. Testifies to not remembering the subject matter. 4. Cannot be present or testify at the trial or hearing because of death or a then existing infirmity, physical illness, or mental illness. Or 5. Is absent from the trial or hearing and the statement's proponent has not been able by process or other reasonable means to procure A. the declarant's attendance in the case of a hearsay exception under Rule 804b1 or 6, or B. the declarant's attendance or testimony in the case of a hearsay exception under Rule 804b2, 3, or 4. But this subdivision A does not apply if the statement's proponent procured or wrongfully caused the declarant's unavailability as a witness in order to prevent the declarant from attending or testifying. B. The exceptions. The following are not excluded by the rule against hearsay if the declarant is unavailable as a witness. 1. Former testimony. Testimony that A. was given as a witness at a trial, hearing, or lawful deposition, whether given during the current proceeding or a different one. And B. is now offered against a party who had, or in a civil case whose predecessor in interest had, an opportunity and similar motive to develop it by direct cross or redirect examination. 2. Statement under the belief of imminent death. In a prosecution for homicide or in a civil case, a statement that the declarant, while believing the declarant's death to be imminent, made about its cause or circumstances. 3. Statement against interest. A statement that a reasonable person in the declarant's position would have made only if the person believed it to be true, because when made it was so contrary to the declarant's proprietary or pecuniary interest, or had so great a tendency to invalidate the declarant's claim against someone else or to expose the declarant to civil or criminal liability, and B, is supported by corroborating circumstances that clearly indicate its trustworthiness if it is offered in a criminal case as one that tends to expose the declarant to criminal liability. 4, statement of personal or family history, a statement about A, the declarant's own birth, adoption, legitimacy, ancestry, marriage, divorce, relationship by blood, adoption or marriage, or similar facts of personal or family history, even though the declarant had no way of acquiring personal knowledge about that fact. Or B, another person concerning any of these facts, as well as death if the declarant was related to the person by blood, adoption, or marriage, or was so intimately associated with the person's family that the declarant's information is likely to be accurate. 5, other exceptions transferred to Rule 807. 6, statement offered against a party that wrongfully caused the declarant's unavailability. A statement offered against a party that wrongfully caused or acquiesced in wrongfully causing the declarant's availability as a witness and did so intending that result. Rule 805, hearsay within hearsay. Hearsay within hearsay is not excluded by the rule against hearsay if each part of the combined statements conforms with an exception to the rule. Rule 806, attacking and supporting the declarant's credibility when a hearsay statement or a statement described in Rule 801D, 2, C, D, or E has been admitted in evidence, the declarant's credibility may be attacked and then supported by any evidence that would be admissible for those purposes. If the declarant had testified as a witness, the court may admit evidence of the declarant's inconsistent statement or conduct regardless of when it occurred or whether the declarant had an opportunity to explain or deny it. If the party against whom the statement was admitted calls the declarant as a witness, the party may examine the declarant on the statement as if on cross-examination. Rule 807, residual exception. A, in general, under the following conditions, a hearsay statement is not excluded by the rule against hearsay, even if the statement is not admissible under a hearsay exception in Rule 803 or 804. 1, the statement is supported by sufficient guarantees of trustworthiness after considering the totality of circumstances under which it was made and evidence, if any, corroborating the statement. And 2, it is more probative on the point for which it is offered than any other evidence that the proponent can obtain through reasonable efforts. B, notice the statement is admissible only if the proponent gives an adverse party reasonable notice of the intent to offer the statement, including its substance and the declarant's name, so that the party has a fair opportunity to meet it. The notice must be provided in writing before the trial or hearing or any other form. During the trial or hearing, if the court, for good cause, excuses a lack of earlier notice. Article 9, authentication and identification. We'll do that later. Rule 901. Woo! Rule 901, and then we got Rule 1001. So all we got are the 900s and the 1000s. Oh, man. That's coming up on Part 3, Federal Rules of Evidence, 2024.